The state witness in the Senzo Meyiwa murder trial, Sergeant Vusmusi Mokhane, is sticking to his guns that accused number 2, Bongani Ntanzi, was not tortured on the day he submitted his confession statement. Sergeant Mokhane says he believed that Ntanzi would have indicated if indeed he was assaulted. The defense, though, maintains that their client did not make the confession statement freely. We're now joined by legal analyst Elton Hart from the University of Johannesburg's Law Clinic to take a look at the cross-examination of Sergeant Mokhane. Thank you very much, Elton, for your time this afternoon. For the purpose of the conversation, let's start with the cross-examination where accused number 2, Bongani Ntanzi, is concerned. This is what we heard, and this is the version of the accused in terms of what happened when the police knocked on his door and some of the details that transpired thereafter. Let's take a look, listen.
When he requested you to produce the appointment certificate, Sergeant Mabena slapped him with an open hand in his face, and he said, "You think you're smart."
In Zulu, I did not see that, and the late Mabena, even from his appearance, it was clear that he was not the assaulting type.
How helpful is this for the court, and is it helpful in regards to the defense or the state?
This is now 50-50 because Mabena is currently deceased, so he cannot, because now we're working with hearsay evidence that the person on the stand currently, Mokhane, is saying that Mabena never smacked the guy and he's not that type of person. So Mabena will never get the chance to come and testify so that the court can check his demeanor to see what type of person he is to actually make a finding as to who is actually telling the truth here. Yes, the accused person will be here. And unfortunately for the accused person, he's sitting a little bit on the back burner because the accused person is the only person that was most probably there, and his Tswana girlfriend, as they would refer to it, I think, that can come and testify to say, listen here, he was smacked by Mabena. If the girlfriend, which we know now, the state called her previously to come and testify, maybe she would come again to come and testify if they smacked him or not. But if they can't get her to come, then it's going to be problematic for the defense to actually now prove that this is actually what transpired.
Here's more detail of what transpired. Let's revisit that moment.
He will come and tell the court that his rights were not explained. Immediately thereafter, you handcuffed. You placed him under arrest.
I told him his rights, and I said that I first told him in English, and I then reiterated in Tswana, and then I reiterated in Zulu again.
And you further showed him the photo of the person. With the tattoos.
Whose picture are you referring to?
And a gold teeth. Whom you alleged that it resembled accused number 2.
No, we did not show him anything. I dispute that.
Again, Elton Hart, how useful is this for the court to determine whether indeed his rights were violated or not?
Now, in this situation now, it's a he said story, because now the person on the stand, Mokhane, is saying that this never happened. This is how I explained his rights to him. Then the accused person is going to say, but you never explained my rights to me. You actually spoke in a different language from what you're saying. So it's two mutually destructive versions. Now the court is faced with actually looking at the demeanor to make a credibility finding to see who is actually telling the truth. And obviously the court also needs to be cautious, because obviously an accused person, when he or she is on the stand, they will say anything to exonerate them, to say, no, that did not happen. And the state is now sort of barred with the burden of proving beyond reasonable doubt. So it is now he said, so the court has to now make that determination as to who's telling the truth, and then thereafter make the decision if this confessions or admissions that they make should be allowed and be admissible in the main trial.
There were times where the witness was getting agitated, if that is the correct word to use, because he would constantly say, but as I said yesterday, or as I put it yesterday, where the judge at some point intervened to say, well, this is what he has said already. When Advocate Mngomezulu was cross-examining him, he went as far as saying, well, if indeed he was assaulted, would he not have died if he was assaulted for such a sustained period of time? What does that, one, tell you about the witness, the kind of witness that he is, and how useful will that be?
This can be one of two witnesses. He's well trained to actually sit on the stand, keep a straight face, and stick to his guns to say, listen, yeah, this is what I'm going to answer. I'm not going to incriminate myself or my colleagues to say that something untoward happened to the accused person. Now it shifts to the accused person to come and prove that this assault happened. And I saw Advocate Mngomezulu, he had some dentist certificate that he was actually showing to them that on this day he was taken to for specific treatment. So if you say certain things, why is this certificate? He never went to court. So he's trying to now bring in the discrepancies in the evidence that was given in chief in the trial, within the trial, compared to the documents. And then if they can't dispute the documents and that person that was actually at that facility on the 22nd, then it becomes like sort of half. Maybe the accused person is telling the truth. Maybe the police officers is actually just trying to protect each other and not really take the court into confidence to say, yes, we maybe ruffled him a little bit to get some information because this is one of our cold cases. So that is now where we're at. And obviously we'll see how the other accused defense teams come after 2 o'clock at this specific witness to see if we can still see if this witness is just well trained over the years how to actually conceal when they actually used extra force, if I can put that word, extra force to actually solicit some answers.
Advocate Mngomezulu said that dentist report is important because it was completed on the 22/06/2020. It was signed by the accused. It was completed after court in Tlhabane, but it has no time because the version of the accused is that he was taken to the institution, the dentist, and he never appeared in court on the 22nd. And the witness insists that the accused must tell the truth because he was indeed taken to court before being taken to the dentist. How do you determine as the presiding officer who is telling the truth? Because both are sticking to their guns.
It's simple. If the dentist or the person that treated him at the facility is available, or somebody like a superintendent at the facility can be called to say, listen, yeah, according to your records, what time did Magano and his crew actually brought the accused person to this facility? They can easily go check the records to see, okay, he was brought there at maybe 1 o'clock, he left the facility at 3 o'clock, then that afternoon session that they say he was at, I think at Boksburg Court to actually make the confession. Now you can bring that into question. But it's simple. You just go to the facility where he was taken, check what time he was booked in, and then you match up the records, and from there you can draw your conclusions to see travel time from that facility to court is maybe 20 minutes. So easily by doing mathematics, you can see he was there or he wasn't there.
Then Advocate Mngomezulu went into the circumstances that led to the arrest of accused number 1. So accused number 1 was arrested on the 30th of May 2020. He was booked on the 31st of May that year in the early hours of the morning. He asked Sergeant Mohane about the date where accused number 1 was taken to an elderly man, an Inyanga, and Sergeant Mohane says he cannot remember that day, but he was present, or he cannot remember the date, but he was present on the day when they went to the said Inyanga, and he was asked on the purpose of that, and he says that Brigadier Gininda and another colleague told him that the accused number 1 said he wanted to show them the Inyanga that they consulted before actually murdering Senzo Meyiwa. How helpful is this for the court, and how to determine who's telling the truth there?
No, the simple thing for me is that if that Inyanga is still alive, call him to come and testify. He must come and tell the court what was the purpose of the visit when accused number 1 was brought there. Was it for them to come and actually verify that he was there before to verify if both of them came to actually consult prior to committing the offense? or what was the purpose. Then if the Inyanga is there, he testifies, we take out all these uncertainties that we might have. But if they don't want to call the person, then maybe one should now think and say, but if they don't want to call the Inyanga, maybe there's doubt that this happened for a very different reason from what they are stating currently on the stand.
Okay, let's go back to the cross-examination on what happened to accused number 2 and his rights. We heard from Sergeant Mohane saying that he indeed told him his rights in English, Setswana and isiZulu. Advocate Mgomezulu asked him to read something in isiZulu, and this is how that went.
Read paragraph 2C.
Paragraph 2C.
The right to be detained under conditions consonant with human dignity, which shall include at least the provision of adequate accommodation, nutrition, reading material and medical treatment at state expenses.
Can you explain it in Zulu?
Unamalungelo akuhlala endaweni le because niki mix alagasi so that's why I can negotiate alagasi so to listen to that ngase.
Well, I was mixing Zulu and English, and when I was talking about this.
Yes, stammering.
I am bound to stammer because that's why I actually said that I used all this language, English, Zulu, and Setswana, because Zulu is not exactly my mother tongue.
Now, how helpful was that, Elton Hart? Because he says he read the accused rights in his mother tongue of isiZulu, yet isiZulu is not his mother tongue, and he was unable to read that document clearly in isiZulu in court.
No, for me, that speaks now to that was his rights was not properly explained to him. And already if you hear Bongani Ntanzi, you can hear this guy. His surname stems from the Ndebele tribes, which means you should either use the Ndebele languages, which is Zulu, or one of the Ndebele languages to explain to him. So you can't go off English, Tswana, and then go to Zulu, and knowing that you are not a fluent Zulu speaker, then why was the services of interpreter not called in? Or maybe one of his colleagues that's actually fluent in isiZulu to come and explain the accused rights. So that to me already, it shows that here it's police officers that understand, and I'm not sure if they're telling the court the truth or are they just covering their tracks to show that procedurally they followed all protocols and procedures that's in place for police officers when taking down admissions, when taking down confessions, when interrogating witnesses. And I think for me, this just speaks to, as much as it's difficult for the defense to show it, but it speaks to me, just police officers just trying to show and covering their tracks that they actually did the right thing.
Elton Hart is a legal analyst with the University of Johannesburg's Law Clinic. Thank you very much for your contribution this afternoon.